The record shall now show that the jury is seated in the courtroom. Ladies and gentlemen, Mr. Wilkerson is present via video in his vehicle. He's pulled over and he had to go to an important health meeting that he needed to make this afternoon. So he is going to be listening and watching live through the video. There he is right there. And the defendant is present. The prosecution is present. And again, for the record, the jury is present. The court has received a message from the jury that the jury has reached a verdict, and I'm going to talk to Mr. Cross. Is that so, sir?
Yes, Your Honor.
Is this decision a unanimous one? That is one that is agreed upon by all members of the jury?
Yes, Your Honor.
And do any of the jurors disagree with your foreperson's representations? No disagreement. It does indeed appear to be a unanimous decision. If you would be so kind, pass the documents to the bailiff. You may be seated. I will review for proper form and publish the verdict of the jury. The defendant shall rise. In cause number 23 CR 1121, the state of Texas versus Brandon Dion Charles Jr., we, the jury, find the defendant guilty of the offense of murder as charged in the indictment. This verdict signed by the foreperson of the jury. It is received and made a part of the record for all purposes. You may be seated, please. Thank you. Ladies and gentlemen of the jury, I have, and anybody, if y'all have to leave, please leave, but do not make outbursts. All right. At this time, I have received your verdict finding the defendant guilty of this first-degree felony of murder. That brings us to a close of phase one of this bifurcated two-part system we have in the state of Texas. We will next proceed with the punishment phase of this trial. And once again, let me repeat, you are still under all the instructions previously given to you in this case. Ladies and gentlemen, here's what's going to happen because the defense attorney is unable to be here this afternoon because of an important medical reason. We are going to pick up Monday morning, 9:30 in the punishment phase of the trial. Punishment phase is always much shorter. Presentation of evidence can be made by both parties. Then the court has a shorter jury charge to give to you. Then the lawyers make their final arguments and you go back to deliberate on the issue of punishment. So these instructions, remember, stay muted about these events until you are released at the end of all of the proceedings and that should be ended by Monday. People will ask you, what can you tell me? Remember, there's still the same instructions. Don't talk about this case yet. The proceedings, your deliberations or anything until the end of the trial when you are released, and that will probably be Monday, unless for some strange reason it would be prolonged, which we don't expect that to happen. But nonetheless, we're scouts. Be prepared, and anything can happen. But this is what normally occurs. So don't talk about this case at all with anyone. And we will ask you to return back at 9:30. Then the parties get a chance to present any evidence they want for you to consider for the punishment phase of the trial. The court has a much shorter set of jury instructions for this second punishment phase. I will read those to you when the evidence is presented. The arguments will be made by the attorneys, and then you will go back together to deliberate on a verdict. That's our plan.